Good morning. Welcome to the Courtroom Files Live. Friday is starting out less like a lion and more like a lamb. It's a little quiet out in the courtrooms, but Judge Meinecke's got a fairly busy docket this morning, so we'll start there.
I'm wondering if it makes sense just to get her on the SoberLink device, Ms. Blakeney, because that's a breath test. She's indicated before that breath tests go better as far as um, there isn't the issue of a false positive. She has to pay for a confirmation test. She pays for the confirmation test that comes back negative. She doesn't get the money back for that. And so that gets to be very expensive for Ms. Ricks. And frankly, with multiple high BACs, the court, if I had set the bond, I would have put a SoberLink on her anyway. So I don't know. My thoughts are, did you post the 750 bond, ma'am?
Yes.
Okay. So my inclination is to, because she's shown up here, she's here today, is to reduce her bond to 250, release some of that money back to her that she can then use for a SoberLink.
Okay. Oh, thank you. Thank
Ms.
you, Your
Ricks,
Honor.
what are your thoughts on that? Can you get that set up?
Yes.
All right, so I'll adjourn this pretrial. I can do it April 11th or April 25th, Ms. Blakeney.
May I check my calendar, Your Honor?
Sure.
April 25th. Because that'll give me some time to speak with Clinton Township and then to go over everything that sobriety court entails with Ms. Riggs.
Okay.
And also, Your Honor, would she contact pretrial services or
Yep.
your
So
probation? Okay.
I'm going to delete the ETGs and I'm going to add the SoberLink.
Okay.
I'm going to reduce bond to $250 and release balance to Ms. Ricks for use to pay for SoberLink. And you can get that money, obviously, you know, we're open till 4:30 today. You can come on Monday, but you can get that money and get that all set up. And then she could just contact pretrial services. And what I would do then for Ms. Ricks is make a note here. Need to have that SoberLink in place by April 1st. So that'll give her some time to get the money from the court to then pay for the SoberLink. And instead of putting it in place right now, where she has to then come up with the money herself before getting the refund from the court.
Yeah.
So Ms. Ricks, just make sure you set it up so you can get here to the court to get that refund so that you can then use that money towards the SoberLink. But I want that in place. And then you'll be testing 4 times a day.
Okay.
Okay.
They'll set up
Your
times. Yes.
Should I contact your clerk for the telephone number? I may have the telephone number for
I've got the
pretrial
phone number for you right here. Let me give
Oh,
it to you.
okay. Thank you.
All right, so and she should have it as well, but it's Angel
She
Brady,
should.
her case manager. It's 248-451-2311.
Okay. Thank you.
All right, good luck, Ms. Ricks. We'll see everybody back here on the 25th.
Thank you. Have a good weekend, everyone.
You as well. Mr.
Thank you.
Schreeman, I've had a darndest time getting your client. Were you able to talk to your client?
I did. We are all set. I just don't know if he's able to leave the breakout room.
I just brought him out.
Perfect.
Once again, for those of you who are just joining, good morning. Happy Friday. Welcome to the Courtroom Files Live. As I explained at the beginning, it is a little bit of a quiet start out there. I've actually only got eyes on 5 different courts. It's normally closer to a dozen, and 2 of them are in recess at the moment. So we'll continue to ride with Judge Meinecke. I do have 1 or 2 fun things planned for today. At least I think they're fun. We'll find out. So hang tight for that. In the meantime, let's listen in on Judge Meineke.
All right. So calling case number 25-00241, People versus Paul Meadow.
Good morning, Your Honor. Courtney
Yeah.
Rosen on behalf of the people.
Good morning, Your Honor. Joe Schreeman on behalf of Mr. Medell, who is present via Zoom. Mr. Medell, can you state your name for the record, please?
Paul Medell.
Okay. Also calling case number 2019-01676, People versus Cassandra Halcomb.
Good morning, Your Honor. Courtney Rosen on behalf of the people.
Seymour Schwartz, Your Honor, on behalf of the defendant.
And Miss Halcomb, state your name, please.
Cassandra Holcomb.
All right, today's date and time set for pretrial on both of these matters. Mr. Medell is going to be pleading guilty to allowing and responsible to violation of basic speed law. The allowing is a misdemeanor carrying with it a maximum possible fine of $500 plus costs and up to 93 days in jail, all at this court's discretion. The violation of basic speed law is a civil infraction. It just carries with it points, but it will result in an additional 1-year revocation of his license. I just want to make sure we're all on the same page with that. And then with Miss Halcomb, she's pleading as charged to domestic violence, but will receive consideration under the Spouse Abuse Act, where if she completes this a term of probation, it will be non-public while she's on probation, and then it will be dismissed when she is done. Is that first? I'll start with you, Mr. Schreeman. Is that the plan for Mr. Medell?
Yes, Your Honor.
Okay. And Mr. Schwartz, is that the plan for Miss Halcomb?
It is, Your Honor.
Okay. All right, Mr. Medell and Miss Halcomb, can you please raise your right hands? All right. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God, Mr. Medell?
Yes, sir.
And Miss Halcomb?
Yes, Your Honor.
All right, go and put your hands down. Mr. Medell, can you read, write, and understand the English language?
Yes, I can.
Can you hear and understand me?
Yes, I can.
Miss Halcomb, can you read, write, and understand the English language?
Yes, Your Honor.
Can you hear and understand me?
Yes, Your Honor.
All right. Mr. Medell, have you had a chance to talk to Mr. Schreeman about this case, and are you satisfied with his advice?
Yep.
And Ms. Halcomb, have you had a chance to speak with Mr. Schwartz about this? Are you satisfied with his advice?
Yes, Your Honor.
All right. Mr. Medell, you're pleading guilty to allowing unlicensed person to drive. That's a misdemeanor charge carrying with it a maximum possible fine of $500 plus costs and up to 93 days in jail, all at this court's discretion. Ms. Halcomb, you're pleading guilty to domestic violence. That's a misdemeanor carrying with it a maximum possible fine of $500 plus costs and up to 93 days in jail, all at this court's discretion. Before you enter a plea, you should each understand you have the right to represent yourself or be represented by an attorney. If you cannot afford an attorney, one will be appointed for you at public expense. You have the right to a trial by me or by a jury. At that trial, you'd have the right to confront, cross-examine, question all witnesses brought against you. You'd have the right to have the court subpoena witnesses on your behalf. You'd have the right to testify if you wanted to, remain silent if you wanted to, and no one could say anything about you remaining silent. As you appear before this court, you're presumed innocent of these charges, and your guilt has to be proven beyond a reasonable doubt. Mr. Medell, do you understand that once you enter a plea, you give up all those rights that I just said that you have at a trial?
Yes, I do.
All right, Ms. Halcomb, do you understand that?
Yes, Your Honor.
And Mr. Medell, do you understand that once you enter a plea, there'll be no trial?
Yes.
And do you understand that, Ms. Halcomb?
Yes, Your Honor.
All right, Mr. Medell, you received a plea bargain where the primary misdemeanor is being reduced. Other than that reduction, has anybody else promised you or threatened you in any way?
Nope.
All right, Ms. Halcomb, you're going to get the opportunity to discharge off your record by way of the Spouse Abuse Act. Other than that, has anybody promised you or threatened you in any way?
No, Your Honor.
All right, in the end, Mr. Medell, is it your own choice to do this?
Yes.
All right, and Ms. Halcomb?
Yes, Your Honor.
All right. All right, Mr. Medell, directing your attention to January 23rd of this year, 2025. Were you in the city of Royal Oak in the area of 696 and Campbell?
Yes.
All right, do you plead responsible to violation of basic speed law?
Yes.
And did you allow an unlicensed person to drive your vehicle, that person being you?
Yes.
Satisfied, Ms. Rosenau?
Satisfied, Your Honor.
Satisfied, Mr. Freeman?
I'm satisfied, Your Honor.
I too am satisfied. The plea is knowing, voluntary, and accurate. I will accept the same. We can go forward with immediate sentence because of the additional revocation. He's not an Operation Drive candidate. But I do appreciate Mr. Medell's willingness to accept responsibility. The court will, despite the fact that his license was revoked at the time, and he should not have been driving, the court will not impose a jail sanction here, but rather a financial sanction that I will give him plenty of time to pay.
Thank you, Your Honor.
So anything you'd like to say in his behalf before this court imposes sentence?
Your Honor, I would just note that he is currently on disability. He's not able to work according to his doctors. And the court, he did have some alcohol-related driving issues, back quite a few years ago. So the court did require him to participate in testing at the arraignment. And as a result of those tests, I believe he tested negative. So it does appear that he's trying to turn his life around. He does want to drive at some point, but understands that he's not eligible for Operation Drive. He would just ask the court to consider minimal costs and fines, and of course, give him some time to pay.
All right, sir. Is there anything you'd like to say before this court imposes sentence?
Nope.
All right. Bear with me 1 second. Bear with me 1 second, everyone.
Little Bill Withers going in the background there. That's a good song. That probably means we'll also get demonetized later.
I'm sorry, everyone. I just need to double check the fine on the violation of basic speed law. That's 130. All right. Mr. Medell, you just can't be driving. And I know it's the things that revoked your license were a long time ago. And I wish that there was, that there would have been an effort to try to get this done, but you know better than I. Every time you picked up a ticket, it revoked it for another year, and then eventually people just give up. But the actual revocation, and the record should reflect this, the actual revocation of his license was from 1988, if I'm not correct. Is that right, Mr. Medell?
Oh, I couldn't even tell you, sir.
Yeah. Since then, he has picked up tickets, so he has been driving, which is certainly not acceptable. But I haven't had any new drinking and driving offenses or reckless driving or dangerous driving since then. But but sir, you're not supposed to be driving, so there does need to be a financial sanction for that. It's $130 on the violation of basic speed law, on the allowing an unlicensed person to drive. It will be a $300 fine plus $300 in court costs and $125 in state costs. I know he's on a fixed income, so I'm stretching this payment plan out in a substantial way. So the grand total altogether is $855, but I'll set up a payment plan. And we'll go $25 a month, starting April 15th. Can you do that, sir?
Yeah.
All right.
Yep.
Obviously, the more you can pay, the better, but I need you to start the $25 a month payments starting on tax day, okay?
Yep.
All right. Good luck, sir.
Thank you.
Thank you, Your Honor. And Your Honor, I'm going to zoom up to the courthouse and zoom in for the Butler matter from the parking lot.
That's fine. All right.
Thank
Ms.
Okay, good morning again. For those of you who are still joining us, welcome to the Courtroom Files Live. Going to move to Judge Fleischer here in just a second because he just came online a couple of minutes ago, but I wanted to finish up with that hearing that was there. couple things. First, you'll notice I am wearing our Property of Harris County Criminal Court at Law number 5 t-shirt. Stand up a little bit so you can see it a little better. Show off my belly, which I'm still working on getting rid of. Something fun for you, because I promised you a couple fun things today. I am, in a moment, going to drop a link in the chat to this shirt. It's one of my favorites. Mrs. The Courtroom Files and I, one of the businesses that we have is an apparel business, so this is something that we do, and we've done it for a long time. But in the Courtroom Files store, we have this shirt, and I am going to put a link in there with a code, and if you'd like to get this shirt and if you would like to help support the show by doing it, it's certainly a great way to support the show and support the channel and show your love of Judge Fleischer. I will give 20% off to the first 10 people who get one in the next 24 hours. And that code will be in the link, and I'm going to put it in the chat in just a minute. You're not obligated, obviously, but if you're interested in it and you'd like to help support the show, we'll throw you 20% off. Again, that'll be for the first 10 people who pick that up. So let's go over to Judge Fleischer. I've got something else I want to do with you guys too, but we'll get to that in a little while.
Victoria, sign a reset. We'll have you get with pre-trial for your bond conditions, and after that, you're free to go.
I think you already had the interlock and everything previously. And it's the agency, right? Okay, all right. Mr. Manzor? Can I hear Mr. Manzor first? Just leave it there for now.
Next is page 2. Alexander, come on up.
Do they not have arraignments?
No, Judge. BDRs, one's a Spanish one.
Got it. Okay.
They're not in trouble. This one's off. Okay, cool. Thank you. You're welcome. Thank you.
Good morning, Miss Alexander. Ma'am, you're charged with the offense of driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You are Janae Alexander?
Janaya.
Janaya? So you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On March 22nd, 2025, an officer responded to a minor traffic incident. Upon arrival, the officer met with the wheel witness officer who stated that he was conducting a safety control of a disabled 18-wheeler on the shoulder with his emergency lights activated. The officer stated that he was on the shoulder when he was struck on the driver's side by the defendant's vehicle. After the crash, the officer observed the vehicle to continue to travel southbound. A traffic stop was initiated. The officer made contact with the defendant, the driver, and sole occupant of the vehicle, and immediately detected the strong odor of alcohol upon her breath and slurred speech. The defendant exited the vehicle, and the officer observed unsteady balance. The defendant admitted to consuming alcoholic beverages prior to driving. The affiant officer made contact with the defendant and observed the same signs of intoxication. The defendant stated that she was on her way home from a bar and consumed 1 minute's drink at 9 p.m. The defendant stated she was unaware of when she struck the patrol vehicle. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 6 out of 8 clues observed on the walk-in turn. 2 out of 4 clues observed on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were 0.202 and 0.201.
Any prior DWI and
No prior, Judge.
license?
Oh, yeah.
Okay. Ms. Alexander, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? Ma'am, look at me. If I find that you're using, it's not going to go well for you. I'm not asking much from you. If you do not have a valid Texas license and liability insurance in your name, car insurance, you're not allowed to drive. That is also a condition. Do you understand? How old are you, man? You,
23.
do you have the ability to hire a lawyer? Would you like to apply for a court appointment?
I need one.
Okay. So Deputy Miranda is going to give you an application for an appointed lawyer. I'm going to have you sign a reset with Victoria. We'll have you take a seat in the jury box while you fill it out. You will meet with pre-trial for your bond conditions, then I'll have you talk to someone here shortly. Okay? Please.
This way. Right, Judge, we have the Spanish arraignment on page 15. Rodriguez, come on up.
Good morning, Blas.
Good morning, Your Honor.
Mr. Wong, do you have an arraignment? You're muted.
Buenos días, ¿no se escucha de más tarde?
Yes, Judge,
Okay.
it's for Danny Wong.
Okay, give me a second and then I'll hit you up next.
Thank you, Judge.
What page is this?
15.
15.
15.
Are you Victor Ortiz?
No, Judge.
No, this is Osman Rodriguez.
Yes.
Mr. Rodriguez, you're charged with driving while intoxicated. You're facing up to a year in jail and or $4,000. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 21st, 2025, an officer responded to a two-vehicle accident that occurred near the 5,000 block of Bingle Road. The complainant stated that she had made a right-hand turn northbound on Bingle Road and was already traveling northbound when she was struck on her driver's side by a white van. The complainant identified the defendant as the sole occupant and driver of the striking vehicle. The officer made contact with the defendant and observed red, glossy eyes, the strong odor of alcohol upon his breath, and smoke. The defendant stated he consumed 2 beers, one at work and one in his vehicle as he was driving home. SFSTs were conducted. 6 out of 6 clues were observed on the HDN. 2 out of 4 clues on the one leg stand. 3 out of 8 clues on the walk and turn. The defendant consented to provide a breath specimen. The results were 0.160 and 0.177.
Did they find alcohol in the car? Substantiate that allegation.
Doesn't state in the VIN, Judge.
Does he have a license? And any prior DWIs?
He does not have a driver's license and no prior DWIs.
Mr. Rodriguez, I'm going to find that there's sufficient probable cause to go forward with the case. If you do not have a Texas driver license and liability insurance, you are not allowed to drive. That is a condition of your bond. I will have you sign with me today a promise to me that you're going to make. This is an affidavit that I take absolutely serious. I don't care what's going on in your life. I don't care if you have a bunny that needs operating. If I find that you drive, it's not going to go well for you. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, you will be stuck like Chuck in there until this case is over with, and then you get shipped off to immigration. Do you understand? You're not to consume alcohol, illegal drugs, unprescribed controlled medication, and you will be randomly tested. If I find that you're consuming, likewise, I will revoke your bond, put you in jail. No more PR bonds for you. You have a lawyer. Because you have a lawyer, I will waive your appearance. Mr. Rodriguez, it is your responsibility to stay in touch with him. If Mr. Salinas tells me that he can't get a hold of you because you're playing games, you pick up a new case, you endanger my community, I will put you in jail. For now, I'm going to have you come up here and swear to us that you're not going to drive. I will get you to Victoria. We will have you sign a reset. And then after that, I will get you with pre-trial. And then after that, you're free to go. Come on.
Okay, so yeah, B. Davis, I agree. Sometimes bunnies need operating. So a little bit about us. We have pets here at the Courtroom Files bunker, and we actually have a couple of pet rabbits, and we had one of them actually pass about 7 weeks ago. She actually died in my arms. So that was sad. Now, I love me some Judge Fleischer, but his whole thing with, 50 kittens in a burning building, and now the bunny operating is a new one, but I don't know. I know he's just trying to be cute and funny or whatnot, and I don't take particular offense to it, but it's weird. Anyways.
Yes.
Mr. Sierra, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 23rd, 2025, an officer observed a vehicle engaging in illegal street race at the 12,425th block of Wood Forest Boulevard in Harris County, Texas. Both the defendant's vehicle and another vehicle passed the officer at a high rate of speed while attempting to pass each other in a competitive manner in an attempt to outdistance each other. The officer observed the defendant drive 96 miles per hour in a 40-mile-per-hour zone. A traffic stop was initiated. The defendants began to pick up speed while swerving through multiple lanes and cutting off other drivers on the roadway in an attempt to outdistance each other. The defendant admitted to speeding but denied racing. The co-defendant is a juvenile.
You want his license? See if he has a license.
Yes, Judge. He does not have a driver's license on file, Your Honor.
Mr. Sierra, I'm going to find that there's sufficient probable cause to go forward with the case. You do not have a Texas driver license. You are not allowed to drive. I'm going to have you sign with me today an affidavit, a promise that you're going to make to me that you're not going to drive. I don't care what's going on in your life. If I find that you drive, I will put you in jail. And if you're not in this country with permission and you go to jail, it's very possible immigration puts a detainer on you and you will be in there until this case is over with. How old are you, sir?
20.
Did you want to apply for a court-appointed lawyer?
Yes.
Look at me. Heed this warning. You get no more. If I find that you're a danger to my public in any way, I will put you in jail in a moment's notice. Do you understand? Think before you act. You hang with the wrong people, it's not going to go well for you. Come on. Deputy Mayor, you mind giving him an application? Thanks, man.
Judge, counsel on Zoom is here.
Okay.
Wong, come on up.
Judge, were those state bond conditions?
Yeah, please. I'm sorry, I didn't tell you. Yeah, so no driving, no racing, and all that jazz.
Okay.
Good morning, Mr. Wong. Just so you know, your lawyer's here with you, but he's on Zoom, so you know that you're not alone.
Sure.
Hey, I have a problem. No, it's-
Oh, okay.
All right, Mr. Wong, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 18th, 2025, an officer was dispatched to a call for service in reference to a major crash. The witness stated that he observed the defendant sitting in the front driver's seat behind them and crash into another vehicle by rear-ending it at the 9,000th block of Bel Air Boulevard. The witness stated that he observed the defendant was driving recklessly prior to the vehicle crash. The officer observed a strong odor of alcohol emitting from the defendant's breath, slurred speech, glossy eyes, and slightly unsteady balance. The defendant admitted to consuming an unknown amount of alcohol. SFSTs were conducted. 6 out of 6 food was served on the HGN, and the defendant was unable to perform the walk and turn test in one leg stand due to a past ankle injury. The defendant consented to provide a breath specimen. The results were 0.123 and 0.122.
How many prior DWIs have you run an NCIC?
Yes, he has 1 prior DWI.
Here, anywhere else, anything else? No? Great, license?
He does have,
Please.
he does have a Judge John Wong.
Right, that's who it needs to be, not David.
His driver's license is eligible, Your Honor.
All right, Mr. Wong, I'm going to find that there's sufficient probable cause to go forward with the case, and I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I'm going to put you in jail. No more PR bonds. I am now also placing another restriction on you because it's a second offense. I'm ordering you to obtain an ignition interlock, and you're not allowed to drive any vehicle that doesn't have one. If you're caught driving a vehicle that doesn't have one, you will go to jail. Do you understand? I'm sending notice to DPS in Austin so that every single officer in the state knows. You understand? Because you have a lawyer, I will waive your appearance so you don't have to waste your time coming to court, but you must stay in touch with the other Mr. Wong and he'll tell you if and when you have to come back to court. For now, I'll have you get a Victoria sign and reset. You'll get with pre-chop for your bond conditions and then you're free to go.
Judge, June 3rd through the 5th.
Mr. Wong, did you hear that?
Yes, I did. Your Honor, I just have one question. The vehicle that he is driving to and from
Oh,
work.
is that what
he
you were
also-
about to say? Come on up. So,
It,
what we will
the
do-
ignition. I'm sorry, Judge. Go
is
ahead.
it inoperable, I guess?
It's inoperable at this time. We don't even know if it's going to be repairable. But the point I'm trying to make is that the vehicle that he drives, he shares with his mother. So I don't know if that with the ignition, the system, if that's going to be something that.
You're not allowed to drive any vehicle that doesn't have an interlock on it. So if you're going to drive
Okay.
mom's vehicle, it has to have an interlock on it, and that's it.
Okay, that's just okay.
No, I don't want you driving any vehicle that doesn't have an interlock. I mean, I want to make
Okay,
sure that if you get in the car, there's no alcohol on board. That's it. So
Okay.
if you want to get a portable device and you're telling me you're not going to drive, I'm going to have you sign an affidavit promising me you're not going to drive. So, you know, whatever vehicle you put it in, or if you're going to drive, okay, you got to have one. You make the decision. If
Judge.
you want me to give you a portable device, I'm happy to do that, but you're going to promise me you're not going to drive it.
Okay.
So I guess, just let them know what you want to do. I mean, if you want to take time to think about it, you know, I'm happy to give you time as well.
Yes, Judge. That would be great. Let me confer with my client, and then we'll
Yeah,
decide.
so, you know, go
Okay.
outside, step outside, you talk, and then when you make your decision, just let us know. Okay?
Okay. Thank you, Judge.
Sure.
Judge, I'm gonna get on the side.
Yeah.
Okay, real quick, while he's between things, it was a slower start to the morning. A couple of other courts are starting some action now, so I'll keep an eye on them. We'll stay with Judge Fleischer until something more interesting comes about. I also wanted to share with you, if you recall, a day or two ago, we had a situation with a woman being held in Harris County who was wanted out of Pennsylvania, and the whole breastfeeding in the jail wouldn't allow her to do so, wouldn't allow her to pump either, and Shreya, her attorney, bought a pump and was trying to get it in there, all that. Anyways, I put a poll up on the courtroom files last night. 115 votes on that. 84% of people feel that the jail should have allowed her to pump her breast milk. I found that interesting. Anyways, back to Judge.
Remain silent. Anything you say can or will be used against you, sir.
On March 21st, 2025, at approximately 10 p.m., an officer was investigating a fatal motorcycle accident with emergency lights activated, and the road was shut down from both directions. Accident investigators notified dispatch of a vehicle which disregarded all marked units and drove through the accident scene, almost striking officers and record drivers at the crash site. The officer observed the vehicle traveling at a high rate of speed and cut through an Exxon service station parking lot and turned down another road. The officer followed the vehicle and initiated a traffic stop. The vehicle accelerated and began darting in and out of lanes without using a turn signal. The vehicle then turned and came to a stop. A high-risk stop was conducted and the defendant was taken into custody. A security sweep of the vehicle was conducted and the officer observed 2 baggies of a green leafy substance in plain view on the driver's side seat, known from training and experience to be marijuana. The defendant was identified by his driver's license, and the defendant was transported back to the accident scene, where the accident investigator confirmed the defendant's vehicle was the same vehicle that disregarded the marked patrol vehicles and disregarded the safety of the people on the scene. Other officers who witnessed the defendant's vehicle confirmed this. Deputy Chicoya advised that the defendant's vehicle almost struck multiple patrol vehicles and had approached officers while they had to abruptly move out of the way. And then Deputy Chicoya observed the defendant's vehicle almost struck 2 record drivers who were authorized to be on the scene. The record drivers confirmed this. Witness cross advised he yelled at the vehicle to stop, and the defendant's vehicle began to accelerate faster. The defendant acknowledged he drove through a closed roadway.
Mr. Davis, I'm going to find that there's sufficient probable cause to go forward with the case. Can you run his license? Please see if he has a valid license.
His driver's license is ineligible, Your Honor.
Mr. Davis, you are not allowed to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care if Jesus comes from heaven and needs to ride to church. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Sir.
I'm going to do everything in my power to protect my community. If I find that you drive, much less drive maniacally like this, as they allege, it's not going to go well for you. If you want to drive, go get a license, get liability insurance, and then we can talk. But until that point, if you do, it's not going to go well for you. You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with her. If she tells me that you're playing games, you're not responding to phone calls, text messages, you've gone AWOL, you pick up a new case, I will revoke your bond and put you in jail. Do you understand?
Sir.
I'm not asking much. All I want my streets to be safe. That's it. I'll have you come up here, swear to us you're not going to drive. I'll get you to Victoria, sign a reset, and then you're on your way. Thanks. All right, please. Give me a second.
Counsel.
Go ahead and sign the bottom, Mr. Defense, since you're not now activated. So let's just sign it. Yeah, where's the defendant? No, I swear you. I swear you. Raise your right hand.
He needs to swear you in, sir.
Is your name Corey Davis?
Yes.
Do you solemnly swear and affirm that you will not operate a motor vehicle without a valid driver's license and you know driving whatsoever will escape that?
Yes, sir.
And it's your signature, let's correct here.
I'll sign. If they need, we're gonna do no. This morning.
Sure, we gotta get our judge to sign this. Go ahead, you should sign your reset.
Thank you.
Sure.
Go ahead and sign.
I'm like, what?
Hey.
Just a second.
Yeah.
I'm gonna approach on Miss Jasmine Tobar, but may we step out to talk briefly about the bond violation? She's in the jury box right now, under my custody.
Don't let her leave.
Absolutely. Thank you.
Hey, Vic.
Yes.
So saying I have to sign.
I know. I think they do it differently everywhere else.
It's a head scratcher.
Hey, what?
Are you ready for the next?
Yeah, come on, bring it.
And do you remember what she was saying? Does he have to sign it first or do they sign it first? No, yeah, so he'll sign the other one and not that. Not this one. Okay. The presiding judge signs the top of that one and the new judge signs the bottom. Gotcha. Oh, gotcha. All right, Judge. next.
Hold on. Have you helped them so they can leave? The lawyers? Mr. Salinas, I don't know why he's still.
Sure. ABR is there, jail person, glasses, I don't know what you're.
Do you have an arrangement?
Mr. Wong, tell me, what's going on?
Yes, so my client will accept the interlock.
Who wants the
in
interlock?
vehicle.
Okay,
Yes,
not a
sir.
problem. We'll help him with it then.
Okay, great. Thank you, Judge.
Wait, I need a date, June 3rd to the 5th. What day do you want?
June 3rd is fine.
3rd? Okay, it's yours.
Yes.
It'll be waived for that appearance.
Thank you, Judge.
Okay, take care.
Thank you.
All right, page
Rare.
4, Drake, come on up.
Rest of this. This is Drake Osby, right?
Yes, Judge.
All right, good morning, Ms. Drake Osby. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 20th, 2025, at approximately 9:24 p.m., officers observed a black Chrysler traveling southbound on Kinswood Drive, noting that the rear license plate was not illuminated, making it difficult to see, and a traffic stop was initiated. Upon activation of the emergency equipment, the motor vehicle accelerated rapidly. Based on a loud sound from the motor vehicle's exhaust and speed which it was traveling, the officer believed that the driver was attempting to elude. The motor vehicle made a sudden right turn into a private drive and continued before coming to a stop. The officer made contact with the defendant, who was the driver, and also made contact with the front passenger, who was identified. The officer observed a strong odor of marijuana. The defendant was detained due to furtive movements inside the vehicle. The officer observed multiple open container beverage vehicles, including a Four Loko and Buzzball cans in plain view in the rear passenger area. The officer observed a black bag in the front passenger seat with a 9mm handgun and a green leafy substance inside. The substance was identified as marijuana due to the officer's training and experience. The defendant admitted to possessing both the handgun and the marijuana. The officer observed slurred speech and a strong odor of an alcoholic beverage on her breath. The defendant stated that she consumed one alcoholic beverage at approximately 9 a.m. The defendant performed SFSTs. The HGN was a 6 out of 6. The walk and turn was a 7 out of 8. And the one leg stand was a 1 out of 4. The DIC was read and the defendant consented to breath, which the results were a .121 and a .116.
You need prior to DWI and then does she have a license?
Prior DWIs, her license is eligible.
You said,
It is eligible.
right, but no prior to DWI?
No prior.
Okay. Mr. Drake Osby, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, it's not going to go well. I'm telling you now, I will test you 45 to 50 days from today. If you're still using, it's not going to go well for you. Do you understand? You are not allowed to drive unless you have a valid Texas driver license and car insurance in your name. That is also a condition of your bond as well. Do you have the ability to hire a lawyer, ma'am?
Sure.
You want to apply for an appointed lawyer?
Yes, please.
Okay. Deputy Miranda is going to give you an application. I'll have you fill it out. I'm going to have you sign a receipt, Victoria, and then we'll have you take a signature box name. Please.
This one.
That's the.
All right, Judge, next is page 5, Garcia, Rafael. Judge, you said 50 days for a drug test?
Yeah.
While the next contestant is walking up, just want to let you know I've got eyes on multiple other courtrooms. Judge Fleischer is still the best show in town, so we'll continue with him for a little while.
Yeah. You are Rafael Garcia. Mr. Garcia, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 23rd, 2025, the officer observed a vehicle traveling at a very high rate of speed. The officer was unable to get exact speed, but based on his training and experience, and the fact that the vehicle rapidly passed other vehicles, determined that the vehicle was well above the 35 miles per hour posted speed limit, and a traffic stop was initiated. The officer made contact with the defendant, the driver, and observed an odor of an alcoholic beverage on his breath and person and watery eyes. The defendant admitted to drinking a mixed drink at a party earlier in the evening, and SFSTs were conducted. It was a 6 out of 6 on the HDN, a 0 out of 8 on the walk and turn, and a 0 out of 4 on the one leg stand. The DIC was read, with the defendant refused to provide a specimen, and a blood warrant was signed.
Okay. Any prior DWIs, and does he have a license?
No prior DWIs. His license is ineligible.
Eligible.
Ineligible.
Mr. Garcia, you're not allowed to drive. You do not have a Texas driver license. That is a condition of your bond. If I find that you drive, it's not going to go well for you. Do you understand?
Yes, sir.
You're also not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, likewise, you will go to jail. No more PR bonds. Do you understand?
Yes, sir.
This is an affidavit that you're going to sign with me today, that you're promising me you're not going to drive. Heed this warning. If I find that you drive and you can't justify it by any means whatsoever, if I find that you do, it's really not going to go well for you. I can have a contempt hearing and you'll be facing 6 months in jail every time you drive. Do you understand? If you want to drive, go get a license, get car insurance, and I will do backflips letting you drive. But until that point, if I find that you do, get ready. Do you have the ability to hire a lawyer?
Yes, sir.
We're going to give you time. I'll have you come up here, swear to us you're not going to drive, and get you to Victoria Center reset. You'll get with pretrial, and then you're out of here.
All right, Judge, next is case 6, Gonzalez. Come on up.
It's not the one, just depend. Never spoke to. Wait, right? Is your name that I don't know? Yes, sir. Sounds like
Good morning, Mr. Gonzalez. Do you speak English?
Yes, sir.
Good morning.
Morning.
You're charged with 2 cases. You're charged with evading arrest and resisting arrest. You're facing up to a year in jail and or a $4,000 fine on both of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On March 22nd, 2025, at around 7 p.m., officers were dispatched to 1855 Work Road in Houston, Harris County, Texas, in regards to a criminal mischief in progress. Upon arrival, the officers observed the defendant at a location matching the description on the call slip. The officer gave verbal commands for the defendant to lay on the ground and put his hands behind his back. The defendant ignored commands and ran away from the officers. A foot pursuit was initiated, and the officers continued to yell verbal commands for the defendant to stop running. The officers were able to detain the defendant approximately 100 meters away. The defendant then actively resisted, and the officers had to dry stun him. The defendant was using both hands to push off officers in order to avoid detainment. The defendant grabbed the officer's ballistic vest and attempted to push the other officer. The defendant attempted to push officers multiple times, and the defendant struggled on the ground for approximately 3 minutes before he was detained.
What was he doing wrong? All you said he matched a call slip. So
Yes, for a criminal mischief in progress, Your Honor.
that's completely conclusory. What is the alleged mischief? What did he do wrong? Who did he do wrong to?
And I don't have that information.
Then none of that? I mean, who's writing the reports? Mickey Mouse? You know? I mean, really? I haven't heard anything. I'm going to find no probable cause Mr. Gonzalez, be careful, man.
Okay.
When you get into a pissing match with people who have the power of rest, who's gonna win?
I'm not gonna be more careful. I promise. It's not gonna happen no more.
Be
I
careful.
promise. I got my family. I want to,
Okay,
Thank you.
Got it.
God bless you.
dude.
Next is page 7. Herrera. Herrera, come on up.
Okay, real quick while we're waiting for the next contestant, the other thing that I wanted to do today, I just started a Q&A in the chat. It's an Ask Me Anything. So I'd mentioned yesterday that if we're going to build community, it's important that we get to know each other. So this is your chance to get to know me. Ask me anything you want. I'll answer it. My only rule is I'm not going to discuss politics on this channel. It's not the place for it. But anything else is pretty much free game. And we'll see how this goes today. If it goes well, I'll consider doing something like this every Friday. But let's have at it. Throw your questions in there.
Do you mind reading what happened, please? So you were given a general order bond. Looks like you took on, it looks like we did probable cause, I'm assuming. I found probable cause at the time. We ordered you not to drive, and then I guess went AWOL. You've now made a surety bond. So yeah, do you mind reminding me what happened, please?
On November 5th, 2025, a traffic stop was conducted on the defendant's motor vehicle after it was observed that he had expired registration. Upon contact with the defendant, the officer observed watery, bloodshot eyes and the odor of an alcoholic beverage. The defendant admitted
He's driving. Oh, I mean, this is this case,
prior.
because he just picked up a felony, I see.
Yes, it was a PC.
So I guess, yeah, go forward with this one, and then I want to know what happened in the felony.
Absolutely. The defendant admitted to drinking a can of an empty Budweiser that was found on the passenger floorboard. SFSTs were conducted. It was a 2 out of 6 on the HGN, a 6 out of 8 on the walk and turn, and a 1 out of 4 on the one leg stand. The DIC was read and the defendant consented to breath, but provided unacceptable samples. The defendant then consented to blood, and a blood draw was conducted. And we do have the results of that blood.
You do or do not?
We do.
Okay.
And it came back for 0.05 of ethanol, as well as methamphetamine and amphetamine and THC.
Okay, what happened in the felony?
Yes, Your Honor.
Please.
There we go. On March 22nd, 2025, the officer observed a vehicle displaying a fictitious buyer's tag, and a traffic stop was initiated. The defendant, the driver, provided a Texas driver's license and warrant checks. Provided a Texas driver's license, and the warrant check revealed an outstanding warrant, which led to his arrest, and that would be the DWI. During the inventory search of the defendant's property at Pasadena jail, officers found a clear zip bag containing a white crystal-like substance identified as methamphetamine, which weighed 0.87 grams.
I'm sending you now for a drug test. I want to know what, if anything, is in your system as of right now. If you fail to go test, if you fail to come back, I'm going to revoke your bond and make it so high you will have hair falling out. Do you understand, Mr. Hara? And the next time you miss court, likewise, your bond will reach the clouds. Do you understand?
Sir.
Take your seat for me.
All right, Judge, next is page 8. Jason, come on up.
Hey, Vic, also appoint my lawyer, please. Good morning, Ms. Hickman. Ma'am, you charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 22nd, 2024, at approximately 1 a.m., The officer observed a vehicle traveling on the wrong side of the road and nearly collides their patrol vehicle on Prairie in Maine. The defendant's vehicle ended up on top of the curb about 10 feet in front of the patrol vehicle, and a traffic stop was initiated. The officer observed a strong odor of alcohol emitting from the defendant, disorientation, and slurred speech. The officer asked the defendant to step out of the vehicle, and the defendant stumbled out. The defendant admitted to consuming alcohol and stated that she was coming home from a club. SFSTs were conducted. It was a 6 out of 6 on the HGN, but the defendant refused walk and turn and one-leg stand. The defendant was arrested and was uncooperative during questioning the reasons for her arrest and refusing to provide her name and date of birth. The defendant had 2 intoxicated passengers in the back seat, one of which vomited on scene. The defendant asked to remove her shoes while being escorted to the patrol vehicle, and when they arrived at the jail, the defendant refused to exit the patrol vehicle without her shoes and insisted on being carried. The DIC was read, the defendant was argumentative and refused to provide a specimen. The blood warrant was signed and executed, and she was identified by her Texas driver's license.
Any prior DWIs?
No priors, Your Honor.
You did run a license?
Yes, she does have a valid license.
Okay, Ms. Hickman, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming it, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer? Ma'am?
Yes, sir.
Okay, we're going to give you time. I'll have you go to Victoria, sign and reset. You'll get with pre-chop of your bond conditions, and after that, you're free to go.
Okay,
All right?
thank you.
Yes, ma'am, please.
Okay, again, I have started an AMA in the chat. Feel free to ask me anything. My only rule is I won't discuss politics on this channel. But beyond that, ask me about the Legos behind me. I don't care. Mark wants to know what made me interested in following court channels. To be honest, it was never my plan. I listen to a lot of YouTube, listen more than watch, as I'm doing my other work for the other businesses that we run, and YouTube decided in its infinite algorithm wisdom to start pushing me court videos, so I started watching them, got interested in them, and we've done other things on YouTube, and I just felt like I could bring a different perspective to it. No shade on other channels. I just feel like I've got different views and a different angle. I'm a little older than a lot of the other people who do these things, so I bring a different life experience, and I just found it interesting. So I started a channel, and within a couple of days, all of a sudden we had 500 subscribers, and it took off really fast, and just decided to run with it. So there we are.
Window trying to get inside. The complainant stated that she had no idea who the defendant is and she had never seen him before. The defendant then broke the apartment window with his right fist and appeared to be trying to get inside the apartment. The complainant stated that she was scared for her and her children, who were also inside the apartment.
And it's a mischief?
The complainant stated that the damage was $100. The officer observed the window to be broken and the defendant had cuts and blood on his right hand for breaking the window, and there was also blood on.
You were you're not charged with a series of felonies. Mr. Juarez, I'm going to find that there's sufficient probable cause to go forward with your case, and I'm now going to put an ankle monitor on you so I know where you are at all times, and I'm giving you a curfew. If I find that you're a danger to my community, I only have one place for you. Do you understand? You are not to consume alcohol or illegal drugs. I'm sending you now for a drug test. I want to know what, if anything, is in your system. If you fail to go test, if you fail to come back, I will revoke your bond. Do you understand? You're not to be in possession of any weapons. You're not to go anywhere near where these people live, work at all.
The court's information, there should be it looks like they're complaining all these cases live on the same street that this mischief happened on.
Any connection, you think?
The defendant did state on the scene that he believed that he was at a different apartment on Dunleavy and wanted his mom to let him inside. Explains anything.
Regardless, I'm going to send it for a test now. I want to see what, if anything, was in his system. Guys, on everything, waive the fees for everything, please. I'm going to send you for a test now. come back. Do you understand? If you don't test, if you don't come back, it's not going to go well for you. Take a seat for me. And then do you mind appointing him a lawyer?
You ready for the next one?
Yeah.
Go ahead and sign, please. Next judge is page 11, Melendez. Come on up.
So just a quick update. Normally I like to hop around a little bit, but there's nothing else going on at the moment that I would prefer to show you over Judge Fleischer. So we'll just ride here for now.
You literally pled guilty not 10 days ago, and now you're back again. You now stand charged with the offense of fleeing a police officer. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 20th, 2025, officers were conducting an active patrol at the 15,300 block of Corona Del Mar Drive in Harris County, Texas, and observed a black GMC Sierra traveling at a high rate of speed in a residential neighborhood. The motor vehicle attempted to slow down once they noticed the marked patrol vehicle by hitting the brakes. At that point, the officer observed a defective taillight. The officer quickly turned on emergency lights and sirens to attempt a traffic stop. The motor vehicle failed to signal, making a right-hand turn and continued driving while the officer was behind the vehicle with lights and sirens. The defendant continued driving approximately half a mile at speeds ranging from 10 to 20 miles per hour in a residential neighborhood. The defendant disregarded 2 stop signs. And then
How fast in the residential neighborhood, did you say?
Sorry?
How fast?
10 to 20 miles per hour. A defendant disregarded 2 stop signs and then parked his motor vehicle in front of his residence and opened the motor vehicle door. The defendant was then detained. He stated that he was coming home when asked why he did not stop and was identified by his passport.
So no license?
There is no driver's license on file.
Mr. Melendez, you're not allowed to drive. If you do not have a Texas driver license and you don't have liability insurance, you're not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive. I don't care what you need to do in life. If you don't have either, both, and permission from us, do not drive. Do you understand?
Yes, sir.
Since the 10 days, you put your arms down. Since the last 10 days that you were here, what have you done to change your life? What better have you done?
So I'm always going to school. Right now, I'm doing a job, Chick-fil-A.
That is now a condition. You must do one of either, in school or a job. I'm going to appoint your lawyer today, and I'm going to bring you back in 2 weeks to see what you have done. If you've done nothing, it's not going to go well. You understand? All right. I'll have you sign a reset. I'm going to have you take a seat in the jury box.
Mr. Melendez, what are your prayers? You're gonna have to sign for the driving application. This is gonna be fine. We're not gonna swear you in this document.
So the 2 weeks back for a job or school,
I think that's right now.
just a point.
You swear to confirm you will not operate a motor vehicle without a valid safety.
All right, the next one, Judge.
And no driving was the
Page.
Oh,
Oh, sorry, that's pre-problem
And then
conditions,
just go
right?
ahead and,
Yeah. Yeah. Do you mind filing all those conditions?
Yes. Next, Judge, is page 11, 12, and 13. Saad.
Unreal?
So you're on bond for an interference and a failure to ID from November. A month later, you pick up a criminal trespass. And now you pick up a fourth case, another criminal trespass. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 17th, 2025, an officer was made aware by Voyager Apartment Complex, courtesy officer that the defendant was trespassing on the property. The officer stated that he observed the defendant walking in the hallway of the property and due to previous encounters, knew the defendant to have a criminal trespass warning from the property. The defendant was detained. The defendant has had numerous criminal trespass warnings from the location and a recent arrest for criminal trespass due to being on the locations. He was identified with his Texas driver's license.
Was this the same trespass as the prior one?
Same location, Your Honor.
Same location.
Your Honor, am I able to speak for that?
No. What I'm going to do is I'm going to put an ankle monitor on you so I know where you are at all times. You're not to consume alcohol or legal drugs, and I'm also giving you a curfew. If I find that you're out in the middle of the night, if I find that you go anywhere near this, I'm going to take all your bonds now, and I will triple, quadruple. Do you understand? I'm going to protect my city at all costs. You not have 4 open cases. You have made bond on those cases. If they give you a PR bond, but I'm telling you now, you pick up a 5th case, I'm going to make your bond so high you'll have teeth falling. Do you understand?
That's all.
Tell me about the interference, please.
Yes, Judge. So on November 26, 2024, an officer heard a verbal disturbance in a parking lot while patrolling on foot at an apartment complex. The officer made contact with the defendant and a female. The officer attempted to identify the defendant, who refused to identify himself and stated, "I'm not identifying myself." The officer
Same complex.
Let me check.
Yes, sir.
Stop.
Yes, Your Honor. Same complex.
I don't want you to go within 1,000 feet of this apartment complex. Do you understand?
Yes, sir.
I have a monitor that I'm going to put on your ankle today. If it dings anywhere near there, I don't care what your excuse is. It's not going to go well for you. Your cases are now from November of 24. It is way too much drama for me. So you will get a lawyer today, and in 30 days, is discovery complete on the cases from 24? It's way too much drama. I'm ready to set these all for trial.
Discovery is complete on the interference, Your Honor. And
Very
discovery
good.
is also complete for the previous criminal trespass.
Get ready. I'm fast tracking this trial, 30 days.
Yep.
So I'm gonna appoint him a lawyer today. I'm gonna have him take a seat in the jury box, have him meet with the lawyer. 30 days, it gets set for trial.
Were you done, Judge?
You're not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, likewise, it won't go well for you. You understand? All right, come on.
Okay, well, we're between contestants. B. Davis wants me to explain the studio and what I use, how we juggle between stuff and whatnot. She specifically asked about my mic. I use a Scarlett Studio mic. In my opinion, it's one of the better ones that you can get without going all in on a Shure mic, which are hundreds of dollars. We'll get there eventually, but starting out with this one. I have two computers running. One controls a big monitor that's up on the wall off camera, where generally I keep as many as 15 or so feeds going, and I monitor them. This morning I've only got like 4 because there's just not much going on, but normally there's a ton. And then in the other computer, which controls the live stream, I keep my top 4 that I'm interested in queued up and ready to go so I can switch at a moment's notice. So I'm always monitoring up on the wall. I'm picking the 4 that are most interesting. Those are the ones that are ready to launch in the computer that controls the stream. And that's pretty much it. It's a little bit to juggle, but the more you do it, the easier it gets.
Follow other vehicles too closely, drive without lights when required, and pass on a no passing zone, disregarding the safety of others.
Okay, Mr. Lynn, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run his license, please? Do you have a license? As a condition of your bond, I'm ordering you not to drive like this anymore. If I find that you do, I will revoke your bond, put you in jail. Do you understand?
His driver's license is eligible.
You're not allowed to drive unless you have valid liability insurance as well as a Texas driver license. Do you have the ability to hire a lawyer, Mr. Wynn? How old are you? 18. Okay, we'll provide you a lawyer today. You will be signing bond conditions. I'm telling you now, jail sucks. At 18, if you end up going to jail, they will have a field day with you. Do you understand? I'm not asking much, but if I find that you make my streets unsafe anyway, it really will not go well for you. Okay, I'll have you sign a receipt. We'll have you. I got no more room. Okay. Deputy Miranda's going to detect you where to go. No, don't worry about it. Do not leave until you sign our bond conditions. Do you mind filing that? No reckless driving, racing, street takeovers, donuts, etc. Please.
Are you aware of who's coming to it? And we're just appointing Judge?
Yeah, please.
All right, Judge, next is top of page 14.
Mr. Onikidi, come up, sir.
Co-host Ellie briefly disconnected my audio monitors. Hope I didn't miss anything there. She's going to get banned if she keeps this up. You hear that, little girl? You're going to get banned from the studio. I'm just saying.
Good morning, sir. So you're charged with the offense of falsifying drug test results. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 22nd, 2025, an officer while assigned to the Harris County Toll Road Authority, DWI Task Force, observed a vehicle traveling 87 miles per hour in a 65 mile per hour zone. The officer observed a traffic stop was initiated and the officer observed the strong odor of marijuana, and the defendant stated he personally smoked marijuana earlier that day. The defendant offered to allow the officer to search his vehicle for marijuana. The officer conducted a probable cause search of the vehicle and located a firearm. The officer also found a liquor flask-sized opaque plastic bottle in the glove box with a temperature sensing strip on the top containing a yellow liquid. The defendant stated he purchased the bottle so that he would not fail a drug test to get a job.
Any open cases?
No open cases, Your Honor.
All right, Mr. Onikidi, I'm going to find that there's sufficient probable cause to go forward with the case. Sir, do you have the ability to hire a lawyer?
I actually have a lawyer. I'm surprised it's not here.
You do have a lawyer. Let me see if any documents have been filed. Do you guys see anything? Are they going to, who? Are they, you've hired them?
Yeah, I did hire them a couple of days ago.
But they told you they would be here? Who is it?
He's from Gilligan. I don't really.
Say Gilligan?
Yeah.
I guess let's do this. I'm not going to put any conditions on your bond. Well, hold on a second. Does he have a license?
He does. It is eligible, Your Honor.
You're not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand? That is a condition of your bond. I guess I'll have you sign a reset now. We'll have you take a seat. It's still kind of early. We'll wait to see if they come. Do you have a phone number?
Yeah,
Maybe you
can
can
I
go
call
call them and see if they'll come, and then we can address your, but don't leave until we excuse you, okay? All right, please.
Judge, that's state bond condition?
Yeah.
Okay, Mark wants to know what area of the country we live in, if I have any favorite sports teams. We live in the Sonoran Desert. We are Arizona dwellers, where it's been known to get 115, 120 degrees. Originally, I grew up in Michigan, misses the Courtroom Files in Ohio. We moved out here for family reasons about a decade and a half ago now. Is this where we're permanently going to be? Probably not, but we're here for now. Do I have any favorite sports teams? Not really. I used to be big into sports. I was actually an athlete most of my life, which is why my belly kind of pisses me off a little bit. I'm stronger now in my 50s than I've been in my entire life. I feel better than I did in my 30s. I've made a lot of conscious health decisions, but there was a period in the last decade and a half where we're taking care of family where I wasn't as active, and I got this belly and I just can't get rid of it. But anyways, what I was going to say is, while I was an athlete, sports has kind of left me behind in a lot of ways, and I think it's just a generational thing, but it's hard for me to relate to all of the showboating and stuff, and quite honestly, all of the risk that's been taken away from sports. I kind of like the whole gladiator thing, and the idea that you're putting something on the line. I've always been huge into racing. Not NASCAR though. I don't like NASCAR, more like open wheel stuff, but they've removed so much of the risk from that. Even it makes it vanilla. It makes it pedestrian for me. So it's hard for me to follow now. I mean, I appreciate the skill and stuff. I can't get into it as much anymore. Anyways, back to Judge.
Actually open. All four were pulled to the touch and they were Four Locos. The defendant denied drinking the alcoholic beverages and admitted to being an alcoholic, having a drinking problem, but he stated that he did not have any idea how many alcoholic beverages got into the motor vehicle. SFSTs were refused. The defendant was read the DIC and declined to provide a specimen. The defendant was arrested and a blood warrant was signed and executed.
Mr. Ortiz, I'm going to find that there's sufficient probable cause to go forward with the case. I am now taking away your privilege to drive. You are not allowed to drive. I don't care what's going on in your life, and you are signing an affidavit with me today, promising me you're not going to drive. If I find that you do, I can have a contempt hearing, and every time you drive, it's an offense punishable by up to 6 months in jail and a $500 fine. Do you understand?
John.
You will now get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. If you fail to blow into the device, if you consume alcohol, if you consume illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
John.
If you have a problem with drugs or alcohol, you better address it. Now is the time for you to address it, because if you don't, and it becomes a problem, I will address it for you, and I promise you're not going to like the way that I do it. Do you understand?
Yes, Your Honor.
I am now also placing a restriction on your license that you're not allowed to drive any vehicle that doesn't have an ignition interlock on it. We send this notice to DPS so that everybody in the entire world, or I'm sorry, all officers in Texas know that if you're driving, you must have an interlock, and if you don't, they will put you in jail.
Yes, Your Honor.
No alcohol, drugs, random testing, and the portable device. Do you have the ability to hire a lawyer, Mr. Ortiz?
No, Your Honor.
I can have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you. How much money you have at the bank, what you do for a living, what kind of car you drive, and then I'll take a look to see whether you qualify. Deputy Miranda is going to give you an application. I'll have you sign a reset with Victoria. You'll get with pretrial for your bond conditions, and after that, we'll take a look to see whether you qualify.
Up here, We're driving.
All right, Judge, next is page 16, Ruiz. Come on up.
Which is the thing. Raise your right hand. Is your name Ruiz?
You are Adan Ruiz.
Sir.
Mr. Ruiz, you're charged with two cases. You're charged with burglary of a motor vehicle and tampering with a government document. On the burglary case, you're facing up to a year in jail. Likewise with the tampering, up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 20th, 2025, an officer was dispatched to a burglary of a motor vehicle that occurred in the Old Navy parking lot in Harris County, Texas. The officer spoke with two witnesses who viewed the incident. Witness one stated the suspect motor vehicle pulled up to the complainant's motor vehicle, and the suspect was wearing a camo hoodie and had gotten out and pulled the door handle of the complainant's motor vehicle, attempting to open it, setting off the alarm at the same time. Witness one advised the suspect got back into the car and drove to another area of the parking lot, parked, and waited for the alarm to stop alerting. Witness one stated once the alarm stopped making noise, the suspect drove back over to the complainant's motor vehicle, parked, and the suspect in the passenger seat got out and was able to make entry into the complainant's motor vehicle. The complainant advised that she was walking up to her vehicle when she saw a Hispanic male wearing a camo jacket hoodie sitting in the driver's seat of her vehicle. The complainant stated the suspect saw her walking up, jumped out of her vehicle, got into the passenger side of a vehicle waiting with an unreadable paper plate. And the complainant advised she heard a male tell the driver to go, go, go. Another officer advised he was patrolling when a gold Tahoe, which was the description in the vehicle before, driving at a high rate of speed past him. A traffic stop was initiated of that vehicle. The officer was able to send pictures from the witness showing the suspect vehicle leaving the location to other officers who were able to verify the suspect vehicle. After further investigation and search of the vehicle, a camo jacket was found in the rear seat and a flat pointed screwdriver consistent with the tool that would be used to break the lock on the complainant's vehicle door. Defendant one, Ruiz, is a registered owner of the Tahoe, but the motor vehicle was displaying a counterfeit paper tag that did not come back registered to any person or any vehicle. Defendant one was identified by his VIN number and booking photos. Defendant two, Cerna, was identified with his VIN and booking photos.
Who was the one who actually went allegedly into the car? Was that Cerna or was that Ruiz? And is Cerna here?
No, Judge.
Oh yeah, he has 2 felony warrants. On Cerna, bond gets revoked at 10,002.
I am not able to tell which of the suspects was the one allegedly wearing the camo hoodie and the one that physically entered the vehicle from the dim summary.
Mr. Ruiz, since 2020, felony evading, theft, felony retaliation, assault of a family member, felony unlawful carrying of a weapon, felony theft, and now tampering and a burglary of a motor vehicle. I want you to understand that I'm going to do everything in my power to protect my community at all costs. I don't care who you are. I don't care what color you are. If you're a small farm animal, I will do everything in my power to protect my community at all costs. You are not to hang around with defendant Simpson. I'm going to put a GPS monitor on you and I'm giving you a curfew. I don't want you out in the middle of the night. You're not to use alcohol, illegal drugs, and I'm telling you now, I'm going to test you like crazy. If I find that you're using, it's not going to go well for you. So understand.
Sir.
What do you do in life now? You work?
Sir.
Did you graduate from high school?
Sir.
You did?
No, sir. I got my diploma, my GED.
What are you doing now? Are you working?
Yes, sir.
Prove it. I want to know that you're actually working and that you're going to be a productive citizen. When people have too much time on their hands, they become self-destructive. And you now are headed for a 25-year sentence or an actual death sentence, because people in Houston, they like their guns and they like their cars. And if you muck with the wrong person, they're going to shoot your ass dead. It happens at least once every other month here. We have someone who's dead because of a gunshot because they break in the wrong law. You understand?
Sir.
You are not to go within 500 feet of where this person lives, works. Is it an apartment complex? What is it?
This was at an Old Navy parking lot, Your Honor.
I don't want you going anywhere near there. Is it a park? Is it like a mall? Guys, 9 p.m. to 6 a.m. No drugs, no alcohol, no weapons, no contact with the co-defendant. GPS monitor today with a 500-foot exclusion from where this offense occurred. I will give you a lawyer today.
Sir.
I'm going to do everything in my power to help you straighten up and fly right. And if you force my hand, I only have one place for you. Do you understand?
Sir.
Hang with dogs. You get fleas.
It's a strip mall, Your Honor.
Okay. Whatever that strip mall is, he's not to go there. And then, so Blaze, if you don't mind sending that to them, please.
Absolutely.
All right, Mr. Reeves, I'm going to have you sign a reset with Victoria. I'll have you meet with Preachout, and then I'm going to have you take a seat in the jury box while we get you a lawyer.
Sir.
Go ahead and sign for your recess, please.
Okay, continuing to ride with Judge Fleischer. To be honest with you, there's only one other courtroom of all of them that I normally monitor that I've got my eyes on at the moment, and that is Judge Sheila Johnson in Southfield. And it's not as intriguing as this, so we might as well stay with Judge Fleischer. Normally I like to move around, but it's just not the morning for that, at least not yet. Ellie, leave stuff alone. I'm going to have to ban this cat, I think. And it's unfortunate because she's cute. Let's get back to Judge.
It's okay. We'll just have him a minute. Mr. Ruiz,
Will you come here so we can swear?
you're not allowed to drive. You're signing an affidavit with me today, promising you're not going to drive.
Sir.
Don't. I don't care what's going on in your life. You cannot justify driving for any reason. Okay, who do we have? Vic, who's this?
This is page 18, Smith.
Got it. Mr. Smith, you're charged with 2 cases. You're charged with possession of marijuana. You're also charged with unlawful carrying of a weapon. On the gun case, you're facing up to a year in jail and or a $4,000 fine. On the weed case, you're facing up to 6 months in jail and a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 23rd, 2025, an officer had conducted a traffic stop for expired registration at 567 South Mason Road in Harris County, Texas. The co-defendant was taken into custody for 5 active warrants. The driver was asked to take a bag with him containing his personal items. Inside the bag, the officer contained a small white plastic bag containing multicolored chocolate pills known to be ecstasy and Xanax. The co-defendant claimed ownership of the pills. A probable cause search was conducted and officers located a handgun with ammunition located behind the driver's seat on the floor of the vehicle, a baby bottle containing promethazine cough syrup, and a clear cylindrical container of marijuana. The total weight of the ecstasy pills was 8.4 grams. The weight of the Xanax pills was 118.2 grams. The weight of the marijuana was 0.05 ounces. The weight of the promethazine cough syrup was 5.19 ounces. The defendant, the passenger in the vehicle, claimed to be the owner of the marijuana and the gun and stated that the gun fell out of his pocket and landed behind the driver's seat.
What about magazine and all that? Who's was there a second gun?
No, there was just one firearm, Your Honor.
Did they charge the other gentleman?
Yes.
So how can they charge him with it?
So he took ownership of the marijuana and the firearm, the defendant. Yes. The co-defendant took ownership of the ecstasy.
I thought you said that the co-defendant said the gun fell out of his pocket.
No, the defendant said that.
Oh, got it. Okay. All right. Mr. Smith, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with the co-defendant in this case. Do you understand? I'm also ordering you, can you run his light? He's the driver, right?
No, he was the passenger, Your Honor.
Got it. All right. Oh my. I'm ordering you as a condition of your bond not to be in possession of weapons. Do you understand? Do you have the ability to hire a lawyer, sir?
I'm sorry.
I'll have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you. Are you working at this time?
Yes, sir.
Okay, I need to know everything about you and I'll take a look to see whether you qualify. Do not leave until you sign our bond conditions. All right. So no contact with the co-defendant and no weapons, please.
Yes, Your Honor.
All right, Judge, next is a. I guess that's our last arraignment for now.
Oh, wonderful.
Let me check. Oh, no, we had a late arrival, page 8, but I emailed Anna. The last name is Hunter. I emailed Anna the school.
I just saw Anna.
Did you want to start? or-
No, let's wait for her. Where is Mr. Hunter?
Oh, he stepped down.
Then we'll wait.
We'll wait.
Yeah.
Okay. We should go, we're just gonna wait for.
We'll wait.
That was the last one then, Judge.
Okay, lawyers ready? Mr. Johnson.
Judge, good morning.
Hey.
I'm here today on Joe Greathouse. He's got a pending BVR for a high brass.
Mr. Greathouse, come up. This is the one that you said that he's a truck driver. I had initially taken away his privilege to drive and then we gave it back, right? And now testing positive for alcohol.
It was a high brass. Judge, I'm gonna just tend to this thing. I have. Should we approach?
Sure.
This is, I had my client, we were notified about the BRAC. I had to go to Quest Diagnostics and take an alcohol test. It shows negative. Now, it is a couple days later.
I mean, really?
But if somebody's drinking, Judge.
Really?
Drinking enough that they're gonna violate on a machine, why would they stop? If you've got such an alcohol problem that you can't stay straight on the machine, why would you stop?
That's, no, I don't believe that for a second. That doesn't fly. The only thing I know is that
Judge,
he didn't do a retest like he's supposed to right afterwards.
can I talk? So what he's telling me is that he was getting in the car to start a shift, that he has to start real early, right? He used mouthwash, right? That's what you're telling me. Well, hold on.
Really?
Hold on.
And now it's mouthwash?
Well,
What's next? Abducted by aliens?
Your Honor, I don't think I'm being inconsistent here. He tested negative for alcohol. You tell me.
3 days later.
I judge, admittedly, I told you that. Admittedly, it was 3 days later. But what I tend to the court is, if somebody's got, you know, a bad enough alcohol problem that they can't stay straight on a machine, why would they stop drinking? People that are chemically dependent, they may not be able to stop, right? What my clients, what I've told my client, Judge, is that you can't use any alcohol products at all, right? And you understand that, correct? And so you've got some mouthwash now that is the hydrogen peroxide guy, correct?
Mr. Greathouse, I'm now again taking away your privilege to drive. And I'm now going to put a scram on your ankle so I know that you're not consuming alcohol at any time. And if I find that you do, I'm well within my right to put you in jail right now, Mr. Greathouse. So be lucky that you're not going to jail right now. But if I find that you test positive, and I don't care if the Queen of England comes down and says, let's have tea and crumpets, you test positive for alcohol again. Do you understand me?
Your Honor,
What are you gonna
the
say?
defendant's
Can I work?
license is
He's telling me
coming
you
back
can't
as
drive.
ineligible already.
I'm sorry.
Your
The defendant's
license is, it's ineligible as it is.
I'm gonna have to look at that. I'm not a receipt.
They have access to the Texas Department of Public Safety's driver's license to see whether a license is valid or invalid. They've looked it up and they're saying that your license is not valid at this time. You're not allowed to drive regardless. It's suspended at this time. I mean, I know that you're looking at me like this, but the system is saying it. So don't drive. So what I'm going to do is I'll have you come up here, swear to us that you're not going to drive. After that, you'll get with pretrial for your bond conditions. They're now going to put a monitor on you. This detects alcohol through the perspiration of your skin 24 hours a day. Don't use. You need to be cognizant of everything that you put in your body. You know how many, if I had one strand of hair for every time someone told me that they use mouthwash, my hair would look like Mr. Johnson's hair. Really. That's why we advise every single person, as soon as they're given bond conditions, do not use this, do not use that, do not use this. Regardless as it is, your license is now suspended, so you can't drive regardless. So you guys need to figure whatever that is out, and then we'll talk. All right.
Thank you, Joe.
Thanks. Joe.
Yes, Your Honor. I'm here on walkthrough bond on Jonathan Johnson.
Okay.
Coordinator.
Did you get the cause number?
Yes.
No, Your Honor.
Are you ready?
Yes, sorry, Judge.
It's Jonathan Johnson. Okay. Oh, I think I remember this. Are you here for that, Sebastian? Johnson?
I believe it's a sign.
Is this the one that we had spoken about?
Yeah.
Come up, Mr. Johnson. Hey, can you have Edge going? This guy was working and he put NA on everything. I don't believe that. Can you have him refill it out? Please. And if he wants time, we can send him on his way.
No, I'll be with you. It's one at a time.
Mr. Johnson, you were charged, you were charged with harassment. You were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
And judges, you know the details of this case are.
Quiet.
Just read it.
Officer reviewed a police report from February 4th, 2025, after the officer spoke with the complainant. The complainant stated the defendant, her ex-boyfriend, called the complainant and stated that he was going to kill her and then showed up at her job. The defendant was approached by security and fled the scene prior to contacting the complainant. On February 24th, 2025, the defiant officer called the complainant. The complainant stated that on February 7th, 2025, she told the defendant via phone call to stop harassing her, and the defendant told her he did not give a fuck. On February 12th, 2025, the complainant received an email that stated, "Skip pussy bitch, I just love you." The defendant also sent a 20-second pornography video. The video showed a female laying on her stomach, nude, and the video zoomed in on the female's vagina, with fingers being used to spread the female's buttocks to expose the inside of her vagina. The complainant recognized the hand and the fingers in the video to belong to the defendant and recognized the room. The complainant stated the defendant had previously emailed her on March 16th, 2024 from the same email, sending a picture of himself at work. On February 18th, 2025, the defendant emailed the complainant 6 times. On February 23rd, 2025, the defendant emailed the complainant 9 times. On February 24th, 2025, the defendant emailed the complainant once. The complainant changed her phone number on February 22nd, 2025, because she kept getting phone calls from unknown numbers, and when she would answer, the call would hang up. The officer texted a photo of the defendant from his Texas driver's license, and the complainant identified the defendant.
Pornography video that was sent.
We don't know the ID of the female in the video.
So, yeah, I think it would probably take some more investigating to figure out the activity that be now. Obviously, we can't comment about it. I don't know if it's like recognizes her. But that is.
She would say whether she recognized it was her. I would imagine that there's a whole host.
That's a felony.
Yeah,
If it's.
we haven't spoken to her directly yet, Your Honor.
It's just because it's been a black badge.
Mr. Johnson, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to order you not to have any contact with the complaining witness. I'm going to put a GPS monitor on you so I know where you are at all times. If I find that you go anywhere near this person, if I find that you try to have any communication with this person through any means, I don't care what it is, if it's Snapchat, if it's Facebook, social media, smoke signals, whatever it is, I will put you in jail. I'm going to do everything in my power to protect my community at all costs. I don't care who you are. Do you understand?
Yes, sir.
I'm now entering into what's called a Magistrate's Order for Emergency Protection. This is a court order that identifies Ms. Turner as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. If you violate this court order, the state can and will probably file a violation of protective order. It's one of the worst cases that you can pick up. Do you understand?
Yes, sir.
Okay, we need to talk about bond.
Your Honor, the defendant works for Enterprise. He's an IT specialist. He's been working there for over 5 years. And he's got ties here. He's been living in Houston for over 5 years. And he has child support for 3 children that he takes care of on the weekends. They're with the baby mom on the weekdays. But he does work, and he is working. And so we would ask that, and he's no threat. He's not shown any threat previously, and he does have strong ties. We were requesting a bond of $1,500. We have the bondsman here today who could cover that.
I would be unopposed to a bond of $1,500 if he were to have a GPS monitor with an exclusion code.
I'm
so-
gonna order it.
Yeah, so I'm unopposed to that as long as he has the exclusion code.
Bond will be set at the 1,500 then. You will get no more warnings, Mr. Johnson. Don't, I mean, you're in the free world now. Act accordingly. If I find that you do anything, it's not gonna go well. Do you understand? Okay, all right. So you have a bonding company here now? Okay, he'll have to meet with Shaw first for all the bond conditions, then after that, we can release him to the bonding company. Yeah, for sure. Okay, all right, thanks, Joe.
Judge, the bond was set at what amount?
1,500. Hey,
Judge, may I approach?
how are you, man?
Good, how are you? I have Alexandra Abraham on the docket today. She, I guess she couldn't go to the bathroom, Judge. It's pretty simple as that, but she's here. She's in the jury box if you want to call her up. I understand the court's concerned about it, but
Send her for a test now.
it's fine.
Let her know if it happens ever again, I will revoke the bond.
Okay, that's fine, Judge. Thank you.
And then depending on what the test shows, then we'll come back and we'll.
Okay. Should be fine, Judge. Should.
Yeah, just let Pritchall know that we need to send her for a test. So on page one, page one, I'd like to send her for a test now, please. Yeah, thanks.
Thank you, Judge. May I be excused? Can she leave the jury box?
Oh, no.
All right.
No, but if it's dirty, then we'll have to address it, I guess.
We could do it next week, early next week if you want, Judge.
Yeah, that's fine.
Okay.
Real quick couple of reminders. First, in the pinned in the chat, I have a link to the shirt that I'm wearing. You can see it a little better right here. That's the Property of Harris County Courtroom number 5 shirt. It's one of my favorites that we have in our store. And I do have code Harris20. It gets you 20% off of that if you order within the next 24 hours. That applies to the first 10 people that order. Several people during the stream have started shopping carts. So the first 10 people win. So keep that in mind if you're interested in the shirt. It's a good shirt at a good price. I think you'll love it. I know I do. Also, as well, a reminder, I've got an AMA going on in the Q&A in the live chat. Ask me anything you want. The only thing that's off limits is politics. I don't do that on this channel, but you can ask me about the stuff sitting behind me, any of the judges and what I think of them, my views on faith or the multiverse or the term baby mama. I don't care. Just ask.
Council for reset? Did you just file this motion to? Yes.
Hey, please. Good morning.
Your Honor, I like your codes. Your Honor, I'm approaching on Ricardo Ortega. Your clerk just put a motion to substitute counsel in your queue. We just pray that the court signs it.
Sure. Oh, yes, you were wondering about this. This was about yesterday, right?
Right. And so okay, thank you.
Don't
Your
y'all
Honor.
work together?
Nicole and I, yes, Your Honor.
No, Mr. Landrio, no?
Oh, yes, we did. Yes. Yeah. He's actually no longer with our firm. Mr. Landriau, it's not. But the counsel that's subbing in is Nicole Tamori, and she's my law partner.
Okay, so whatever date you guys want. Just
Thank you, Your Honor. May I be excused?
For sure. Guys, ready? Yeah. We're good. Good morning. Happy Friday. Tell me something nice.
You look pretty today.
Yeah, you look good.
Me too.
This one, we're going to be arguing about bond, but I want to request that the live stream be turned off for this one because the corporal, detective corporal from there asked for these facts not be published as much as possible. Obviously, they have a right in terms of the bond part, but he's concerned because of the manner in which they're extraditing, if that's possible for the court.
Okay, so I guess, you want me to turn off now or?
Whenever the argument starts.
What's the last name?
Robinson Frazier. It's a hyphenated last name.
Guys, hey, do you mind bringing out a Robinson Frazier from back there?
Judge, what are we doing with this? Must you come up with?
Oh, is that, Miss Abraham? I'm sending her for a test right now.
She's to come back?
No.
So what are we doing?
So she'll go, whatever the reset, I guess, set for next week. Yeah, whatever next week.
Okay, I'll get you to sign. Oh, yeah, he was already on.
This is the guy that,
He said he lost his job. He was just putting.
he told me he's working.
No, he said he's not working. I told him to correct it, but that's good. Judge, so you want her back next week for the results, right?
Yeah.
Okay.
I guess what I'll do, I'll apprise you for everything. When you start to get it,
Okay.
Okay? Miss Robinson Frazier,
Yes, good morning.
you are wanted out of the state of Arkansas, Benton County for forgery and second degree and theft of property. Are you asking for a bond, Shreya?
Yes.
Okay. Your lawyer is asking for me to set you a bond. I don't know. I've never met you before.
Yes, sir.
I don't know anything about you. The only way I really get to know you is what state tells me about, perhaps a little bit of facts if they know anything, criminal history, and then we can decide.
Yes, sir. I got you.
So he's asked me to turn off the live stream for a bit. I'm going to do that now. And then
Okie dokie. Be that way, Judge. Let's go over to Judge Sheila Johnson because, quite honestly, it's the only other courtroom with anything going on at the moment. So we'll go there.
I don't know why it takes 2 violations for you to figure that out. You mean you've been on this probation since, let's see, January 2024. You're over halfway done with it. You're supposed to be off January 2020. Let's see, 26. There was a sentence agreement to 2 years of probation with anger management and the HEAL program or the AFFIRM program. Reaffirm, whatever. You've already had 2 violations. Are you in anger management? Or did you even do any of that?
So my therapist does the mental health and the anger management. I don't do an issue like this. I just do compass
Life's something.
journeys.
Life Journey LLC. Now, did you go to the HEAL program? Are you still in it?
Yes. I'm graduating from the second portion because I think it's challenges. So.
All right, Judge Fleischer's back. We can go back to him.
With her mommy and dad, her parents, and her sibling, and
how old is she? How old?
21.
21.
No criminal history from what I see.
That's true.
Do they have are they okay with the bond set?
No, they were requesting no bond in many different words. So I don't want to belabor the point, but in many different words, they were stressing and requesting the court for no bond. And so I don't want to belabor, but
Is it 2B or was
this
it?
is a 2B, but this is over a year investigation.
Well, because sometimes it takes a long time to get.
That's
records,
true.
You know, I mean, I don't want to, unless you tell me that there's something where she's like evaded for a year or she's done something to, you know,
And I stress on them is that while I'll be pursuing no bond, is I told them there is a possibility that the court would grant a bond. But that being said, because of the Arkansas stance regarding this defendant's ability to divert and manipulate funds, is that they're requesting a no bond. So the possibility she can again in upside life because she has an ability to obviously cash she's not supposed to.
I mean, it's a nonviolent offense. Jails are packed to the gills. I'm okay giving her the opportunity, but I want you to understand that we don't play games. You know, if we set you a bond, just please take a seat. We'll help you
Yeah,
out.
my mother's on the way here. I was trying to get your attention. And so that's why I was trying to get your attention.
Oh, I didn't know her family was here.
Who are you?
I'm Charlie Jones. I spoke with the sheriff this morning in regards to this case.
No, let's not talk about the case. Just
No, no.
who are you in relation to her?
I'm Charlie Jones. I'm a precinct sheriff, 392. And we have been working on this case this morning with the sheriff as well as calling Benton County. I don't want to say why I'm saying what I'm saying, y'all, but we love.
Are you a father? Are you related? Or
Go
are
to
you?
church.
Huh? You go to church together? Well, that's nice.
Oh, so are you like?
Yeah, that's why we wanted to speak with you before you finish talking to the judge or the table will come up.
I can stand down, Judge. If
Judge, it looks like she has.
I don't think that-
support.
That's nice. Yeah,
I go to church.
you don't get that much.
So, yes, I'll touch base with him. I've got mother's number.
I'm okay setting a bond, like I said, because it's not, you know, there's a lot worse things in life. And the amount in controversy is not like
it's more the mechanism, but I understand.
I get it. So what do you think as far as an amount? Bueller? Bueller?
About 2,000, Judge. That's more.
I mean, I'm standing on, again, it's just feasibility.
I know. I mean,
That's
I
a
know.
lot
I
of
get you.
skin in the game for 2,100.
Understand that if I set you a bond, we give you 2 weeks from the date of your release to turn yourself in. You have to do it. I don't care who is in here in your life and telling you to do this. Don't listen to the jailhouse lawyers. Don't listen to anybody else. You have to turn yourself in. I'm not going to do this again. So if I set you a bond now, which I'm going to, because I told you I will, time that you release, 2 weeks to turn yourself in. Don't wait till the last day because I don't care what gets in your way. Because like Murphy's Law, what can happen will happen. I don't care if you get a flat tire, abducted by aliens, none of that matters. If you don't do it, I will revoke this bond. I'm going to set it at 0. And this time I will hold you until Arkansas comes and gets you. Do you understand?
And this is one where they've noted is that, because I discussed with them the possibility of the court setting a bond, is that they're going to pursue a parallel governor's warrant anyway in the event that she does not return and she gets apprehended again. So they feel very strongly about it.
So basically what he's trying to say is that if for some reason you don't go back and that we rearrest you, they're going to get a governor's warrant, meaning a warrant it takes 90 days to get, and you will sit here waiting for that. And then at that point, we're going to hand you back to Arkansas. So it takes a long, long time. So that's why we're giving you the opportunity now to go do it. Just do the right thing. That's all we're asking you to do. Okay? Okay, Shreya, you want 2,000? Done. All right?
Yes, Judge.
Good luck. Anna.
Hey, Associate.
Hi. Let's do it.
So I'm here on Mr. Hunter. He had an issue, he bond forfeited, he's back for an arraignment today. I've spoken with the state, they've made an offer. We're asking for one setting for Mr. Hunter to consider that offer. And then the state is going to eval the case if not, and if reasonable minds still disagree.
Where is Miss? I don't even see Mr. Hunter.
He's in here. Mr. Hunter?
Has he made,
Yes, he bonded out.
sending him for a drug test right now?
Okay.
I don't know what you have offered. I like it.
And just,
I'm gonna tell you now that it's not gonna be this revolving door anymore.
right.
No more revolving doors for you, Mr. Hunter. You understand? If I find that you're using, it will not go well for you. You come to court whenever you want to come to court. Well, that's not the way it works. I'm sending you now for a drug test. I guess we'll come back Monday and address the results because it's now 11 o'clock. I don't know.
Okay.
I just don't know if it's enough time.
Okay. And Mr. Hunter just informed me, he drug tested yesterday. So I don't know if we have those results yet.
The pre-trial people,
But yeah,
the pre-trial people that I'm auditing the drug test, maybe Monday and
I don't know how because there was no order from us. If he's on the land and then he makes bond, those bond conditions are valid, you know what I mean? So we can't just.
Okay. Shh. Okay, so when he was released, there were bond conditions in place that he needs to report on Monday and Thursday for drug testing.
Okay.
And so he did that yesterday.
Did he test?
Yes, he did, Judge. He did, from the drug test that I see, yesterday. He did consumption, deposit for. Okay, I'll let this. All right. So yeah, for the deposit for THC, Endo, Oxy, and.
You will now test every Monday and Thursday. You test positive for anything else, it's not going to go well for you. You understand, Mr. Hunter? Now is the time for you, once again, to address any issues you may have. If you don't, I'm going to address it for you. Okay? So we'll let him go now.
Okay.
Continue with the same bond conditions that we've always had.
Okay.
And then he'll test again on Monday.
And so just to let you know where this case is heading, the state has asked for one setting to eval it. And then, if reasonable minds still disagree, then we're gonna, set it for a dispositive motion to suppress with the court's permission.
I don't know. I mean, I'm just gonna set up a trial.
Okay, we can do that too.
It's just way too much drama, man. I'm not gonna, you know, just
Well, we'll have to see.
let a jury decide.
So you'll go do
So-
we'll stand down, Judge.
Yeah, just, okay. Anna will continue like always. He's gonna be back Monday and
Okay.
test.
Let's go.
Thanks.
Morning, Judge.
Hey,
May I approach you?
yeah, come on. What you got?
It's a bond violation for Ms. Tovar Martinez.
Come up, Ms. Tovar, Ms. Tovar. I'm sending you now for a drug and alcohol test. I want to know what, if anything, is in your system. I don't know what I'm going to do if you test dirty, but if you're clean, I'm going to let you go. And I'm now going to put a monitor on your ankle so I know that you're not consuming. If I find that you do, it's not going to go well for you. Do you understand?
Yes.
Okay, so let's send her now. It's now late, so we'll have her come back Monday and then we can address everything on Monday.
Perfect, Your Honor. Just a little bit about her. She is attending SOP and IOP through,
She's still testing positive, so
I understand.
apparently the IOP and SOP.
So we just wanted to let you know that she does have a plan to attack any issues in the future that she may have. Thank you. Well, may I be excused?
Okay, well, there's a lull in the action. Just to update you, it continues to be a very quiet morning across the country in courtrooms. A lot quieter than I normally see on a Friday. Everybody wanted a 3-day weekend, I guess. We usually call it a break at about the 2-hour mark. I'm going to continue to go for a little bit while here, see if anything else pops up. I'll give you a few more minutes. If you have any other questions that you want to throw in to chat, please do so. We do have an AMA going on. Ask me anything you want. You can ask about me, ask about my thoughts on judges, about Legos, about sports, about the weather. I don't care. Get to know me. We got a few more minutes.
Right, go ahead and sign for your receipt.
Hey, can I go to the 7th floor real quick? I think.
Good luck. What do we have? Well, why is this attached? Oh, this is a waiver. Okay, that's what.
So yeah, we'll pop into Judge Johnson here for a few minutes.
That Mr. Shudder says. Well, is he here? Mr. Ramon, is it? Romani Jones? Are you here? Come on up. Okay. This is case number 24S00523FY and M4149435A and B. And these are all people of the state of Michigan versus Romani Jones.
Good morning, City Section. We have 5 people.
And what's your name, sir? Okay, and so the one case, which is 24S00523FY, that's the felony charge of larceny in a building, and Mr. George Shedrow is representing you on that. You already spoke to him today and signed a form to waive your right to the preliminary examination on that charge of larceny in building and send the case over to circuit court for trial and further proceedings. Is that right? Okay, so I'm going to mark that file as waived. And we'll continue the bond on that. Okay, so for the other file, it is a pretrial failure to stop at the scene of a property damage accident. That's a 90-day misdemeanor. Went up to a $500 fine, and I believe that one has points, 6 points on your driving record. You also have another matter that's a civil infraction, improper lane use. That went into default, so you currently owe $210 on that because you did not respond to the ticket within 14 days. So currently it is in default, so you understand those two matters. All right, so you have a right to have a trial on this property damage, failure to stop at the scene. You have a right to have a lawyer on that. If you wanted a lawyer, you couldn't afford a lawyer, we'd have someone appointed to represent you. What's your pleasure? I don't know if you wanted to talk to the prosecutor to see if there was any offers, but you could do that, or you could request a lawyer if you like.
Judge, I did have a chance to talk to Mr. Sugar, who I believe spoke with his client about this a little bit. He could plead no contest to the misdemeanor. I will dismiss the civil infraction. It's my understanding that he may have tried to plead guilty at the counter or tried to already pay on the ticket at the counter.
What ticket? The improper lane use? I don't think so, but let's check that out.
And I think he did post a bond on the misdemeanor, so I would have no objection to fines and costs on the misdemeanor, just applying all of his payments to that.
What did you say exactly? Let's see what we got here. Let's see. Click on JIS. Oh, I want to do that backward. Yes. All right, so so the A case is the failure to stop at the property damage accident, and that says this is $75. Oh, that's a bench warrant fee. So you got a bench warrant fee on this failure to stop because he didn't come for a court date. December 15th, 2022. So that warrant got canceled March of this year. And it got scheduled for today. It says cash or surety. $250 he posted on that. Failure to stop. Okay, and on the other one, it just shows $210 on the improper lane use. And that was from 2022 as well, when he didn't appear and it got a default and then extra fees because of that. Okay, so we were trying to figure out what he posted. It was $250 on the failure to stop. Okay, so you could speak to a lawyer about it if you wanted to, and of course I would adjourn it. And if you're eligible, which you probably are since you had a lawyer appointed before, I'd get you a lawyer to talk it over. Or you could waive that right to talk to a lawyer, and you can take advantage of offer that was made to you today, which was to set aside the default judgment and dismiss the improper lane use, and you would just be pleading, I guess, I don't know if it's no contest or guilty, but you'd plead to the misdemeanor failure to stop at the scene of a property damage accident. She was recommending simply a fine. Of course, I don't have to follow them at you.
I take a comment.
I didn't say I was going to give it. That's what she recommended. So, that she can recommend that. I could say, yeah, it's fine. Or I could find out more about you and say, well, no, I'm not going to do that. I could do something else. I could make it take a class. I could, join it, make you take a class. I could put you on probation, or I could just fine you. Okay. So you still want to take advantage of that? Okay. Let's go over the constitutional rights that you do have at trial that you're getting ready to waive because you're pleading. And these are your constitutional rights. So if you understand them, just say yes as I go over each one with you. Starting with the fact that you do have a right to trial by judge or by jury and with a lawyer to represent you. You understand you're going to waive that right. At that trial, you also have the right to subpoena witnesses, meaning to ask the court to order witnesses to come forth to testify for you. You understand you're going to waive that. Also, you have the right to question through your lawyer any of the witnesses that are brought against you by the prosecution. You understand that you're going to waive that. You have the right to testify on your own behalf, but if you choose not to, no one can hold that against you. You understand you're waiving that. And you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt by the prosecution. You understand you're going to waive that. If you're on probation or parole and you plead today, your plea might be considered a probation or parole violation. You understand that? You did sign an advice of rights form and read it, or no, you did not. Do you have any questions now that you read and signed the form about anything on this form?
No, ma'am.
Understand that if I do accept your plea today, you will not have a trial and you'll give up all the rights we've gone over and the rights that are on this form. You also understand that the form does talk about appealing, and you'd have to have a right to appeal or request the right to appeal. And you'd have to do that if you wanted to within 21 days of being sentenced and request a lawyer for an appeal within 14 days of sentencing. So you understand that. And otherwise, you're waiving your rights. You understand that. And you understand the penalties involved here with this failure to stop the scene of a property damage accident. And you wish to plead to that charge. Anybody force you, threaten you? You've been promised anything? Other than the dismissal of that civil infraction. Other than that, anything else? Are you pleading guilty freely and voluntarily?
Your Honor, we presume plead no contest due to civil liability.
Okay, well, what am I going to use? What's the civil liability? Did they have an accident?
Yes.
Yeah. Okay. All right. So what am I using for the
Similar
constitution?
to the base of the ticket.
I could do that. All right. So I'm going to look at, this is the ticket M4149435A, dated November 24th, 2022, 7:11 p.m., which indicates that the defendant, Mr. Romani Jones, operated a 2014 red Ford motor vehicle on northbound M10 The Lodge Freeway, which was near Southfield Road, which are highways open to vehicles in the city of Southfield. And so I will accept his plea because the ticket indicates that he failed to stop at the scene of a property damage accident and may have struck another vehicle in the passenger rear and continued driving. So that's sufficient. So I will take that as a no contest plea. People satisfied?
Yes, fine.
And I'm satisfied as well here with the factual basis for the plea. I believe the court rule has been complied with, and I will accept this plea, finding that it is freely, understandably, voluntarily, accurately, and knowingly made. Okay, and I set aside the default judgment and dismiss the improper lane use. Okay, anything you wish to say? Okay. You work? What do you work? Oh, what do you drive or? Okay. All right, anything you wish to say?
No, Your Honor, other than the fact that you fines and costs would be appropriate.
You have a $75 warrant fee on this. And I'll take a $250 fine. So you're gonna owe 75. You got that today? Okay. All righty, so we'll get that paid by 3/28, and I will apply the bond. So you don't have to come up with anything for the fine, but just for that, the warrant fee. All right, you're all set.
Thank you.
Okay. Just got a couple of more matters.
Okay, I think on that note, we're going to go ahead and call it a day. Judge Fleischer's court is still very quiet. Judge Johnson was the only other show really going on. A lot of courts ended early or just didn't even run today. So it's been a quieter day, but I had fun here. I hope you had fun too. One reminder, really, if you're interested in the shirt that I'm wearing, our Property of Harris County Criminal Court at Law number 5 shirt, which is my personal favorite of everything we've designed. You can find that at courtroomfiles.com. The first 10 people in the next 24 hours that use code Harris20 when they buy that shirt do get 20% off, so it's a good deal. And it's a great way to support the channel. So give that a look and pick one up if you're interested. Have yourself a good weekend. Find things that make you happy, things that bring you joy, and be thankful for those things. Embrace them this weekend. And take a deep breath and just enjoy life a little bit. We'll see you Monday, 10 a.m. Eastern, 7 a.m. Pacific. Take care, and God bless.